My lady, my lords, the examples...
I thought I'd see you.
The dilemma of which way to disappoint. The examples I'd given you were section 17 and section 18. Is there anything beyond performing diplomatic functions? I ought to emphasise, for a reason I'll come to in just a moment, that the on behalf of the United Kingdom in section 17 on page 707 and the for the United Kingdom in section 18 on page 708 are quite significant. But an example in the same legislative map would be if we took section 13 on page 702 and supposed a Scottish bill providing that Scottish Parliament approval is a precondition to ratification of an international agreement, or in this case, the withdrawal agreement. And that I would also accept would engage this narrow, reserved matter. What we showed in our printed case at page 174, paragraph 12.6, is that the explanatory notes to the 1998 Act, this is page 174, paragraph 12.6, and the quote comes from page 3745, say this: the reservations on international relations does not have the effect of precluding the Scottish ministers and officials from communicating with other countries, so long as they do not purport to speak for the United Kingdom or reach agreements which commit the United Kingdom. So I misspoke when I posited saying Scottish ministers speak for Scotland, and I've been shown, and I'm grateful for it, that there's a memorandum of understanding that hits this point bullseye at page 3824 and 3825, volume 10, tab 79, and it's a single paragraph, D 4.6.
3824?
Sorry?
3824.
3824, my lord.
Paragraph?
Paragraph D 4.6. It's under the heading Formulation of UK Policy and Conduct of International Negotiations, and it's making the point at 4.6 that the devolved administrations can have discussions with their counterparts in other states or international organisations and can, in cooperation, make arrangements with them to facilitate cooperation on devolved matters, providing the arrangements don't purport to bind the UK in international law, affect the conduct of international relations or prejudice UK interests, which indicates that it is envisaged that it is very much a narrow provision. And just in support of that, to round off, you will have noted that international relations falls within the head foreign affairs. It's foreign affairs, etc., because alongside international relations, including relations with territories outside the UK and including relations with the EU and including relations with their institutions, you then get, and with other international organisations, you then get regulation of international trade, international development assistance and cooperation. Those are not within international relations. They are added to international relations because they are the etc. And if you take my practical example of my children's rights instrument, and I submitted before lunch that the mere fact that you are dealing with something that was the product of negotiation and agreement, this is a good example, it was a loose document, it's a 2011 measure, and it deals with the implications for Wales of the Convention on the Rights of the Child. Convention on the Rights of the Child, which is scheduled to it, was adopted and open for ratification in 1989, see Section 8. But the point I want to tease from this, if you look at Section 2 of that instrument, it requires for Wales a children's scheme setting out arrangements. You won't find that in the Convention on the Rights of the Child. If you had to go through paragraph 7 and come back out through paragraph 7.2, you couldn't do it. And so the fact that you're doing something that relates to the product of an international human rights agreement that was negotiated decades earlier is not taking you into foreign relations where you purport to speak for or bind the United Kingdom for the purposes of this narrow provision. And finally...
Do we have the Welsh children's measure in our materials?
Yes, it was handed up this morning, I hope. It may have been my mistiming. I perhaps was supposed to give a nod to somebody for which...
I haven't seen it.
I apologise. I'm very glad you've asked me then. What you're about to see is the 2011 measure at the time when the Welsh Assembly made measures, and it gives further effect, see the preamble, in Wales to rights and obligations set out in that convention. The convention is defined on internal page 5, section 8, and is then scheduled at page 8 in the schedule. Section 1 is a good example of an international obligation. You won't find it in England, you will find it in Wales, because we are entitled within competence to enact rights. And the point I was just making is on internal page 2, the children's scheme, 2.1, you won't find that in the Convention on the Rights of the Child, and I won't repeat the submission I've made. Finally, though, it's worth remembering that when Wales had a different model of conferred competence, you had to be in a set of provisions in a schedule, rather than you're in, unless you're within a reserved matter, foreign relations did not feature. So conferring environment, agriculture, on all of the other areas didn't cause a problem. And that again reinforces, as in our submission, all these points reinforce that this is a very narrow provision. Those really are my submissions. I know the Lord Advocate's got to come back to one piece of homework that he was asked about the Charter. If there is any time I haven't used, I donate it to the court. Thank you very much.
Thank you, Mr. Fordham. Yes, Lord Advocate.
Thanks.
Yes, my Lord Sumption asked me whether the incorporation of the Charter in Section 5 of the Scottish Bill was ambulatory or not. And my submission on a proper reading of the provisions as a whole, it's not ambulatory. And I say that partly because of the limitations in Section 5, subsection 1, but also because in Section 5, subsection 4, it's made clear that the retained devolved charter means the Charter of Fundamental Rights, so far as forming part of Scots law by virtue of subsection 1, as modified by or under this Act, or by any other provision of Scots law from time to time. So making clear that after exit day, it would be for the Scottish Parliament, or indeed the UK Parliament, with consent to
Yes.
Amend it.
Thank you very much.
And of course, that's of course without prejudice to the provisions in relation to interpretation and the in section 10 and the provisions in relation to looking to jurisprudence of the Court of Justice. So that, I think, is the piece of housekeeping. I should say, my lady, I've also had the benefit of a brief discussion with my learned friend, the Advocate General, over the lunch break, and it struck me it would be helpful to the court in relation to the question of modification.
Yes.
If I produced a table or a document that dealt with each section in turn,
Yes.
identified what my position is in relation to it, so far as is necessary, identifies where that's to be found, or briefly summarises where that what the position is. My learned friend, as I understand, is quite content and will produce either a counter document or his own adjustmts to the document. So with a view to assisting...
Scott schedule, yes.
Well, a Scott schedule or two documents. I should say the intention is not an opportunity for elaborate additional submissions, but to help the court in terms of just taking each section in turn and identifying what our respective positions are, if the court would find that helpful.
Well, without in any way wishing to suggest what conclusion we have reached on the anterior question, I don't think the effort will be wasted.
Thank you. And I should just, as a final point, in my list of provisions to which there is no analogue, of course, I forgot to mention section 17.
Good.
Thank you very much.
Thank you very much. Attorney General.
Good evening, my lords. The lawn has been fairly comprehensively mown, so I have the relative luxury of engaging with a few stray patches. I want to make submissions on 7 areas. Firstly, the issue of the relevance of the UK Withdrawal Act to this reference. Secondly, the constitutional context and the role of constitutional practice. Thirdly, the issue of a presumption of validity for devolved legislation, and in particular here, the role of Section 101 of the Scotland Act. Fourthly, the meaning of modify in Schedule 4. Fifthly, what is meant by relates to, particularly in the context of relates to the Parliament of the United Kingdom. Sixthly, I want to say a little about the reliance by my learned friend, the Advocate General, on the Christian Institute case. Seventhly, and finally, I want to look briefly at what both the Bill and the Act say about the Charter and general principles of European law. So, to the first issue. Is the UK Withdrawal Act relevant for the assessment of the competence of the Scottish Bill? And our short answer is no, it's not. The Scottish Parliament has done its work. And it's important, though it's easy to describe a bill or an act as competent, the attribute of competence is something that belongs or doesn't belong in a particular case to the Scottish Parliament. Can I invite the Court to take up the Scotland Act and look firstly at Section 28, which is at 424, MS 424. Subsection 2, proposed acts of the Scottish Parliament shall be known as bills, and a bill shall become an act of the Scottish Parliament when it has been passed by the Parliament and has received royal assent. So I invite the Court to note that Parliament, the Scottish Parliament, has done all that it could. Its work is complete. And just to make good textually, that I don't imagine for a moment it's contentious, Section 29, just further down the page, same page, MS 424, an Act of the Scottish Parliament is not law so far as any provision is outside the legislative competence of the Parliament. Again, it's the Parliament that is or is not, in any particular instance, competent. The submission of bills for royal assent is addressed by Section 32, MS 427. It is for the presiding officer to submit bills for royal assent. And while the presiding officer can make certain assessments at earlier stages, there is no suggestion that he exercises any independent function. He acts simply, in classic 17th century terms, simply as the servant of the Scottish Parliament. Of course, it would be strange if the Parliament of Scotland, having done all that it could reasonably be expected to do at the time when it completes its careful consideration of bills, to be retrospectively visited with a finding of incompetence. Now, of course, it's absolutely clear that the Sovereign Parliament could do expressly precisely that. but as we shall see, it has not done that. And among the tasks that lie ahead for the court, obviously is an assessment, in any event, both of the terms of the Scottish Bill and of the UK Act. But the 2018 Act, in common with the normal canons of interpretation, is presumed to be prospective. The court already has the point about the choice of Schedule 4, which protects provisions, rather than Schedule 5, which protects policy areas, in shorthand. And one might have thought that the objectives, so far as one understands them, of the UK law officers would be better addressed by having the UK Act placed in Schedule 5. But even though that would have thrown out the ramparts more widely, it would not itself have had retrospective effect, although it could have had that been expressly provided for, and we know that it wasn't. Now, there are alternative models, and I want to draw the court's attention to the approach of the Government of Ireland Act 1920, and that's in Authorities Volume 3 at tab 11, MS 1181.
1181.
1181, yes, my lady. And under the heading Conflict of Laws, and obviously, and I'll take the court to Quackett in a moment, this is the provision as originally enacted, and of course one sees the stamp of the All-Ireland solution that was then in contemplation. So subsection 2, where any act of the Parliament of Northern Ireland deals with any matters with respect to which that Parliament has power to make laws, so pausing there to use modern language, a transferred matter, which is dealt with by any act of the Parliament of the United Kingdom passed after the appointed day and extending to the part of Ireland within its jurisdiction, the act of the Parliament of Northern Ireland shall be read subject to the act of the Parliament of the United Kingdom, and so far as is repugnant to that act, but no further, shall be void. So, whenever a UK Act would enter the field after the appointed day, the devolved Act was tanto void. Interestingly and importantly, there developed a certain practice around that, as we shall see from the extract from Quackett, which is in Authorities Volume 9, tab 71. It's the last tab, and it's MS 3678 going over to 3679. So Quackett, starting at MS 3678. Quackett, after reproducing the text of Section 6, adds his commentary. And he says this: various acts passed by the Parliament of the United Kingdom since the appointed day and applicable wholly or partly to Northern Ireland contain a provision to the effect that such act or some enactment thereof shall, for the purposes of Section 6 of the Government of Ireland Act 1920, be deemed to have passed before the appointed day. And he gives some examples of that. So the approach set out in Section 6.2 that the Act of Parliament commanded the field and that the devolved Act yielded pro tanto could be circumvented, again, by a technique well known to drafters of temporal, artificial temporal effect. And indeed, special provision could have been included in the UK Act to deal with such matters. And the point is made, of course, that a bill can be repealed, but the provision could have been placed in the reserved matter schedule with an addition that it had been there from a point antecedent to the passing of the Scottish bill, or a variety of other techniques saying that the subject matter couldn't be addressed or any attempt to legislate was ineffective. We find none of that in the 2018 Act, and therefore we say, in accordance with the usual canon of construction, an Act is designed to be prospective. The 2018 Act doesn't sound on the competence of the Scottish Parliament, that Parliament having completed its work well before the Act of the UK Parliament received royal assent.
You're assuming that the monarch, in giving her assent to an Act of Parliament, is not acting as part of Parliament. Because the orthodox constitutional view is that statutes are passed by the Lords and Commons and the Queen, each of whom have their own role in the constitutional process that we call Parliament. It's not just the assembly of MPs and
Respectfully agree,
peers.
my Lord, as respects the sovereign Parliament, which has grown up organically and has its own, the law of Parliament. But the Scottish Parliament is a creature of statute. And the Parliament that is referred to in Section 28 and Section 29 does not, may I say for reasons of obvious constitutional delicacy, also include the Crown.
Why do you say that?
Well, because
her consent it's not like a local authority which simply exercises statutory powers. The monarch gives her assent to Scottish parliamentary legislation because it is within its defined area of competence sovereign.
Quite so, my Lord. And one sees in Section 28, again, provision for the ways in which royal assent is to be made manifest. But as a matter of construction and in terms of the assessment of competence, of course, the assessment of competence is an exercise that never has to take place with respect to the sovereign Parliament of the United Kingdom, but it does with respect to the legislatures of Wales, Scotland and Northern Ireland. The role of the Crown, we say, is quite distinct. So, can I turn then to the second area of submission, which is really the constitutional context? And I want to make 3 points. Firstly, that the Northern Ireland Act in Section 5, and this is at tab 12 of Authorities Volume 3, MS 1187, deals with acts of the Assembly. It is an analogue to Section 28 in many ways, though not all, of the Scotland Act. Section 5, subsection 6 provides, this section doesn't affect the power of the Parliament of the United Kingdom to make laws for Northern Ireland, but an Act of the Assembly may modify any provision made by or under an Act of Parliament insofar as it is part of the law of Northern Ireland. So that isn't in Section 28, but it's implicit in Section 28, and not least as my Lord Reid has elsewhere held. The position, we say, is identical for all material purposes with the position in Scotland. Of course, in the course of exchanges yesterday, between my learned friend, the Lord Advocate, and my Lord Sumption, there was the sense that one was peering into something potentially of a constitutional abyss in relation to the to and fro between the two legislatures. But the British Constitution, as a majority of this court held in Miller, MS 1081, paragraph 40, events and conventions, among other things, have played their part in the formulation of the British Constitution, or to put the matter another way, constitutional practice. I take the reference in paragraph 40 to events and conventions to be synonymous with constitutional practice. And we give an historical example of that in Authorities Volume 3, in Section 4 of the Irish Free State Constitution Act, 1922, and that is at Authorities Volume 3, MS 1180. And this was the document which gave effect, among other things, to the Anglo-Irish Treaty. But if one can look at Section 4 at MS 1180, nothing in the said Constitution, that's the new Constitution of the Irish Free State, shall be construed as prejudicing the power of Parliament to make laws affecting the Irish Free State in any case where, in accordance with constitutional practice, Parliament would make laws affecting other self-governing dominions. Of course, one had a provision which might well have been regarded as extraordinary in the political context of Ireland in 1922, but it wasn't exercised. Of course, one knows that the Statute of Westminster put that matter beyond argument in 1926. But nonetheless, there is a formal provision, but good constitutional practice, which is a leitmotif of the British Constitution, prevents the crises that come from a narrow textual insistence of powers, out with that context of good practice and institutional civility. Thirdly, looking at the issue of whether the bill enjoys a presumption of validity, and is Section 101 of the Scotland Act relevant in answering that question? The case against any presumption of validity is discussed in paragraph 10 of our case, MS 186, and I want to make 3 points about the case against. Paragraph 15 of Lord Hope's judgment in Imperial Tobacco, MS 916, rejects a presumption of validity arising from the referral mechanism. And secondly, paragraph 7 of his judgment, MS 915, rejects the same way any presumption that arises from the absence of an invocation of the referral mechanism. And of course, we now know that account must be taken of Section 63A of the Scotland Act. That's MS 452, I beg your pardon, 452. The Parliament of Scotland is, among other things, part of a permanent feature of the UK constitutional arrangements. So what Lord Hope, we say, is certainly not doing is rejecting generally any kind of presumption of validity. The positive case for a presumption of validity comes from the analogy with the presumption of constitutionality in Irish constitutional law. And a prefatory point to this submission is that the presumption of constitutionality in Irish constitutional law is not a doctrine derived from any particular text conferring such a presumption or piece of armour plating on the work of the Oireachtas. So can I ask the court to look at the case of ZS against the DPP? It's in Authorities Volume 9, tab 63. And although the statute is different, the Criminal Law Amendment Act 1935, it's a familiar case essentially of the issue of mens rea in unlawful carnal knowledge cases. So an issue not unfamiliar to this court. And
Could I have the MS number, please?
yes, it's MS 3591. And the particular passage in the judgment of Mr. Justice Fennelly on behalf of the court is at 3594 going to 3595. So one has the origins of the doctrine in paragraph 21. As the court has explained, the principle springs from and is necessitated by that respect which one great organ of state owes to another. We say that has an obvious relevance in relation to that Parliament, which is now part of the permanent constitutional arrangements of the United Kingdom. And then what is described as the corollary to that in paragraph 22. An important corollary of that principle is that a court, considering the exercise of that constitutional power, must apply the principle of double construction, where the legislative provision under examination is reasonably open to two or more interpretations, one of which is compatible with the Constitution and the other or others of which are not. The court must adopt the former interpretation. We say that is a judicial statement of what is provided for by Section 101 of the Scotland Act. Importantly, the doctrine isn't confined to the 1937 Constitution, which reinforces the point that it's not something which is in any way adhering to a particular text, because in paragraph 25, the point is made that this 1935 Act would have enjoyed the presumption of constitutionality vis-à-vis the 1922 Constitution, but not as against the 1937 Constitution. And I let the court read paragraph 25. The issue is put a little differently in an earlier Supreme Court case of Buckley, which is at tab 60. MS 3595. And if the court would turn forward to the judgment of Mr. Justice O'Byrne at MS 3508, and he puts it, I emphasise, slightly differently. He says, where a particular law is not expressly prohibited and it is sought to establish that it is repugnant to the Constitution by reason of some implied prohibition or repugnancy, it has already been laid down in this court that such repugnancy must be clearly established. So he speaks not in terms of a presumption, but of the necessity that the repugnancy, his word, be clearly established. And he then refers to the origin, the respect which one great organ of state owes to another. So I hope I don't dangle a vulgar temptation before the court, but of course, if the 2018 Act is not relevant for the assessment of the competence of the Scottish Parliament, then of course we will have to go through in some very great detail the provisions of the 2018 Act, including interpreting them. And as we shall see when I come to the final stage of these submissions, looking at the Charter and general principles of European law, the 2018 Act is far from clear as to the possible effect both of the Charter and the general principles of European law after exit day.
Tony, in relation to this argument you've been presenting, I should say that you've taken us to what Lord Hope said in Imperial Tobacco at paragraph 7, with which the other members of the court agreed. In the inner house, we were referred in that case to, not as it happens, the Irish case law, but case law from Australia, which said really much the same thing, that in assessing the constitutionality of legislation passed by the Australian Parliament, the court should effectively apply a presumption in favour in order to respect the will of the democratic people and the democratic will of the people. And we rejected that approach in the context of the Scotland Act because it wasn't a situation where you were simply measuring the constitutionality of legislation against a constitution. Rather, there were two pieces of legislation you had. You had an act of the Westminster Parliament in the Scotland Act and an act of the Scottish Parliament which was being considered. And both of those were expressions of the democratic will of the people. And in that situation, we thought that the Australian authority wasn't really in point.
Well, but one could see, and certainly I would be urging this course upon the court, that the rationale in the Irish cases is different. It's one of interinstitutional respect, and that's one which gets around the issue which I can see does exist in our particular constitutional arrangements.
Don't we have to show equal respect to the UK government as to the UK Parliament as to the Westminster Parliament?
Well,
as to the Scottish Parliament.
But when it comes to the issue of interpretation, that's why what Mr. Justice O'Byrne says, that it's different if there's some very clear, where, for example, if one imagines entirely flawed analogy, no doubt, but that it's the equivalent of a court of limited jurisdiction that exceeds its jurisdiction. But that's not remotely what's at issue here. It's an issue of interpretation. And therefore what is contained in the Irish cases, we say, is of great assistance. And that takes us to the fourth head of submissions and the meaning of modify in Schedule 4. And that's dealt with in paragraphs 20 to 23 of our case, MS 191, 192. And we make 5 points about the meaning of modify. Firstly, modify, as addressed in Schedule 4, is not a synonym for relates to in section 29(2)(b) of the Scotland Act. They are two quite separate categories. Secondly, as the title of Part 1 of Schedule 4 makes clear, MS 541, it is provisions that are protected, not policy areas. And thirdly, it may be helpful to consider, by way of example, paragraph 1(2)(f) of Schedule 4, which makes the Human Rights Act 1998 not, of course, at issue in these proceedings, a protected enactment. The Scottish Parliament would not, on our submission, modify the Human Rights Act if it were separately to either create another right, for example, as in Wales, something to do with the UN Convention on the Rights of the Child, nor, we go further, to domesticate a right that is already in the Convention, that is the European Convention on Human Rights, but is not in Schedule 1 of the Human Rights Act. So, for example, if the Scottish Parliament were to create, without textual interference, with the Human Rights Act 1998, a general prohibition on discrimination, such as that contained in Article 1 of the 12th Protocol. It could do so without modifying the Human Rights Act 1998.
Provided that was in relation to non-reserved matters.
Absolutely, and confined to Scotland. Yes, respectfully agree with it. Now, fourthly, the submission of my learned friend, the Advocate General, in truth seems to proceed as if the submission by the then Dean of Faculty, that is recorded in the last sentence of paragraph 44 of Imperial Tobacco, MS 924, was accepted. And of course, one knows from the succeeding paragraph that it wasn't. Additionality without textual interference isn't modification. And plainly, legislative technique matters. And the best possible example of that, of course, is the asbestos diseases reference. And in particular, paragraph 34 at MS 974, where, of course, it's argued that another route would have worked. Indeed, my learned friend, Mr. Fordham, who then appeared for interveners in that case, accepted that the other route would have worked. And we'll have a look later on at the technique. I say the adroit and elegant technique that the drafters deployed with respect to the Scottish Bill. Fifthly, the word modify should not be overcomplicated. And we commend the short and pithy approach given by Lord Reid in the Inner House, Authorities Volume 7, tab 39, at MS 2988. Sections do not, in my opinion, modify the 1992 and 2002 regulations. Those regulations continue in force as before. The point is not readily capable of further elaboration, and respectfully agree that modify, we have the definition. It includes repeal, lest there be any thought that extinguishing something wasn't modifying it, but it's a pretty straightforward test. And it's not met in this case.
So what's the paragraph in?
It's paragraph 152, right at the top of the page, Moody. And then turning to the idea of relates to, particularly in the context of Parliament. And I'm grateful to my learned friend, Mr. Fordham. He points out that the words of Lord Reid were actually specifically endorsed. The reference is MS 924 at paragraph 44. That's Lord Hope endorsed that approach. I'm grateful to my learned friend. So relates to Parliament. We know that an Act of the Scottish Parliament can amend or repeal, as respects Scotland, an Act of the Sovereign Parliament. That activity plainly cannot come within the reserved category of relating to Parliament, on the ground that Parliament may then have to or choose to go over that ground again and address a policy issue addressed in an act of the Scottish Parliament with which it disagrees. And it's tempting to see that the the Lord Advocate's submission really isn't so much about relating to Parliament. His concern is not about this bill relating to Parliament, but it relates to the work product of Parliament. It does not deal with the power of Parliament in any meaningful sense in terms of adding to, far less subtracting from that power. What it deals with is a power granted by Parliament, and it interferes with that power exercisable as respects ministers of the Crown and only in relation to Scotland. Stepping back a little and attempting to preserve a sense of reality, the reservation is designed to prevent, and it has its analogue both in Wales and Northern Ireland, it is designed to prevent any temerarious effort by any of the devolved legislatures to encroach on Parliament in the formal sense, either in its privileges or its powers. It couldn't, in fact, in any sense be competent to do it, even in terms of the general grant of competence in Section 29, but lest there be any even formal assault on the powers and privileges of Parliament, this is why it's present as a reserved matter, and this bill doesn't remotely come close, we say, to offending against that prohibition. I then turn to the effect of the Christian Institute case and the Lord, my learned friend, the Advocate General's argument based on it. This is discussed in our case, paragraph 39, MS 1967. And I can deal with this very briefly because my learned friend Mr. Fordham touched on it. The Advocate General relies on this case to support the proposition that a provision not yet in force may yet go beyond competence. But of course, in the Christian Institute case, paragraph 84, MS 2834, timing wasn't the issue. In that case, which concerned, among other things, the Article 8 challenge, the way in which Part 4 of the Act under consideration was drafted was not in accordance with law. No future contingency could sound, no future contingency could operate to benefit that provision. It was never going to be enforced because it fell at that fairly early Article 8 hurdle. Second useful point I want to extract from the Christian Institute case is the distinction that is acknowledged in paragraph 63, MS 2836, about the difference between relates to and modify. I then turn finally to what the bill and the Act say about the Charter and the general principles of European law.
Can I just ask you, just before you come to that, the discussion a few minutes ago of what's meant by modifying a provision, where you went to what I'd said in Imperial, but I wonder if what Lord Hope said may also be useful, or maybe perhaps more useful. The circumstances there were that there were two existing provisions which created offences in relation to the sale of tobacco products. There was a prohibition on the sale of tobacco for oral consumption, and there was also a prohibition on the sale of tobacco above a given strength. And what the new legislation did was to create two new offences. One was displaying tobacco products publicly for sale, otherwise than in accordance with regulations. And the second one was selling them by means of vending machines. And what Lord Hope says is that that the new provisions do not seek to amend or otherwise affect anything set out in the existing provisions. So the existing provisions aren't amended, nor is anything set out in them affected. Would you be content with that way of approaching the concept of modification of a provision?
Plainly, the formulation adopted by Lord Hope isn't constructed by him as a statutory provision.
No.
And therefore, there might be difficulty or otherwise effect. If it's confined to what is done with the Act, in that case, very straightforward, the criminal offences continue to exist the day after the new Act is in force, then indeed. But I'm concerned that there is perhaps fluidity about otherwise effect. Certainly,
Well, I think what you would say is, if it doesn't affect, it certainly doesn't modify.
Absolutely.
But it can possibly affect without modifying.
respectfully agree, my Lord. I'm grateful.
Thank you.
Turning then to the Charter and general principles of EU law, can I invite the Court to look again at Section 5 of the Bill, at MS 213. And it may be helpful for those who see the advantage of using paper as opposed to the electronic version to also have open Section 5 of the Act, which is at MS 690.
I have found this one of these cases where a combination of paper and screen is the most beneficial.
Well, I
We have to compare texts from time
indeed.
to time.
I can't say how reassured I am that your ladyship has said that. It is support for, or at least partial support for, technophobes such as myself.
There's no support at all.
Well, I feared that my Lord Kerr might say something to that effect. So, if one looks firstly then at the bill, gratefully adopt what my learned friend, the Lord Advocate, says, that the Charter isn't ambulatory. As I read Section 5 of the bill, the Charter crystallises as a part of Scots law and will then, after exit day, develop organically as a part of Scots law. Setting aside issues about nominalism, it's not really the Charter anymore after exit day. It's a part of Scots law.
So when you speak about developing organically, you mean being developed by the Scottish legislature?
Yes.
Yeah.
And the Scottish judiciary.
Yes.
And then if one looks at Section 5 of the Act, MS 690, the Charter of Fundamental Rights is not part of domestic law on or after exit day. Of course, if matters stopped there, there would be a degree of clarity, and the bill might have to, again, if contrary to our submission about the relevance of this Act, might have to be measured alongside that. But it doesn't stop there. Section 5, subsection 5, subsection 4 does not affect the retention in domestic law on or after exit day in accordance with this Act of any fundamental rights or principles which exist irrespective of the Charter, and references to the Charter in any case are, so far as necessary for this purpose, to be read as if they were references to any corresponding retained fundamental rights or principles. So how is that to be approached? Well, we know that there will be corresponding retained fundamental rights or principles. Whence are they derived? And they are derived from the retention in domestic law of fundamental rights which exist So the Charter, in terms which we say are identical to that, albeit that the technique, the legislative technique is different, here a corpus of law is acknowledged to exist. It will take its own course. And again, the Charter, the real Charter, one can describe it that way, ceases to have a place in UK law, but the domesticated Charter will continue to have an effect. And support for that comes from the first schedule to this Act. So can I ask the Court to look at paragraphs 2, 3 and 5 of the schedule? And they are at MS 717, 718, 719. So paragraph 2, no general principle of EU law is part of domestic law on or after exit day if it was not recognised as a general principle of EU law by the European Court in a case decided before exit day, whether or not as an essential part of the decision in this case. Now, the implication, the necessary implication, we say of that is that a general principle of EU law is part of domestic law if it was so recognised. Now, there may well be, in the future, required a good deal of forensic archaeology in terms of finding out to what extent the general principles of European law are expressed in decisions of the Court of Justice. 3, over the page, there is no right of action in domestic law on or after exit day based on a failure to comply with any of the general principles of EU law. Now, again, by analogy with the approach to the Charter, and in a way that mirrors what is in Section 5 of the Bill, this only works, in our respectful submission, if there is a distinction between that which is created and retained by paragraph 2 and then the prohibition on the new material. That is the general principles that are generated after exit day by the Court of Justice of the European Union. One can still, in our respectful submission, rely upon that which is impliedly created by paragraph 2, but one can't rely on new rights, principles that come into being after exit day. And importantly, paragraph 5 aids that interpretation in our respectful submission. References in section 5 and this schedule to the principle of the supremacy of EU law, the Charter of Fundamental Rights, any general principle of EU law, or the rule in Frankovich are to be read as references to that principle, charter, or rule, so far as but otherwise continue to be or form part of domestic law on or after exit day in accordance with this Act. Accordingly, among other things, the references to the principle of the supremacy of EU law in section 5.2 do not include anything which would bring into domestic law any modification of EU law which is adopted or notified, comes into force, or only applies on or after exit day. So, again, I'm not devoting remotely to this submission anything like the time that its intrinsic importance deserves, but
well, you are out of time, in fact, Mr.
Probably shouldn't have said that. Now I've been rumbled. But immediately, my lady, my lords, can see that one will need to if my learned friend, the Advocate General for Scotland, is right that this is in some way relevant to the issue of the competence of the Scottish Parliament in passing the bill, then this court will have to decide what these provisions mean in order to properly assess this as against the bill. So, legislative technique matters. The Scottish Bill, quite apart from considerations of the wisdom or the policy of a devolved legislature addressing something which, and one can see the force of the argument that the policy issues are often better addressed centrally, is nonetheless elegantly and adroitly drafted. One can see that it may have caused teeth to gnash in Whitehall, because it has a number of prophylactic provisions which, in my respectful submission, do operate successfully. And therefore, I respectfully ask the Court to answer the reference in the way that we suggest in our written case. And can I finally adopt the entirety of that written case, subject to the errata which I hope the Court has?
Thank you very much indeed, Mr. Attorney. Thank you. Advocate General?
My lords, my lady, I must confess that from time to time in the course of the submissions, I began to wonder why we were here. And it's perhaps...
Well, if you don't know that.
Well, indeed.
Nobody does.
And that's why I put it in those terms, because, of course, my learned friend, the Lord Advocate in particular, comes forward to say there isn't a problem here at all. There isn't an issue. And perhaps I can just begin by reminding the Court about the genesis of the issues that now form part of the issue. And it's perhaps most simply done by simply looking for a moment, not only at the Scotland Bill, but at the policy memorandum that accompanied the Scotland Bill to explain the position of the Scottish Government. And that can be found at MS 274. Paragraph 6 at the top of the page. The introduction of the bill does not mean that the Scottish Government has resolved to reject what is now the Act and rely instead on this bill. If the necessary changes are made, then this bill can be withdrawn and a legislative consent motion lodged by the Scottish ministers. And then at paragraph 11 on the following page, there are a series of observations about why there could be no consent recommended to the UK bill as it then stood. And 4 bullet points follow. The first is it concluded that clause 11 of the bill was incompatible with the devolution settlement in Scotland. That is now section 11 of the Act. And there are various other points, but the whole point was that the Scotland Bill was designed around the idea that the Scottish Government would not accept the devolved settlement proposed in the UK Bill and now expressed in Section 12 and Schedule 2 of the UK Act. And while it may be suggested that there are parallels, that there are apparent duplications, that there are apparently restatements of some of the provisions in the UK Act, the position remains that there are in fact very material differences with respect to the way in which the UK Act will operate with respect to the devolved legislatures and the way in which the Scotland Bill would operate in respect of the devolved legislature in Scotland. And I'll come back to this in a moment, but essentially it is clear, and it was the intent, that the Scotland Bill would affect the operation of the UK Act. Now, what I propose to do is essentially to address 2 issues which I would suggest are material and which arise out of the submissions already made to the court. And the first matter that I'll seek to address is the issue of the reservation in paragraph 7 of Schedule 5 to the Scotland Act and the matter of the test of relating to. And the second matter that I will seek to address is the proposition that the Scotland Bill does amount to a modification of the UK Act. There is a third issue, of course, which is the detail of the provisions of the Scotland Bill, which we say affect, in other words, modify, the provisions of the UK Act. But as my learned friend, the Lord Advocate, indicated, it was proposed by him, and I agree, that we would either produce what we regarded as a joint table equivalent to a Scott schedule, or we will each in turn make submissions in writing to the court, with the leave of the court, setting out where we consider that the provisions of the Scotland Bill clearly affect, in the sense of modifying the provisions of the UK Act. So if the court is content with that course of action, what I would intend to do is to address essentially 2 points. The issue arising out of paragraph 7 and the reservation there of international relations, and the matter thereafter of modification of what is a protected enactment in terms of Schedule 4 of the Scotland Act. And I don't seek, I hasten to add, to indulge in repetition of submissions already made to the court with respect to this reference. I'm essentially attempting, I hope, to respond to the points which have been made in regard to the reference itself. Now, just on that matter of paragraph 7 and the test of relating to, there is, of course, no statutory test. There is, however, an instruction in section 29, subsection 3 of the Scotland Act as to how the criterion of relating to is to be applied, and that is by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. But there is, of course, the test in the case law that was referred to earlier from Lord Walker in Martin against Most. That is something having a connection which is more than a loose or consequential connection. And I would just note that that was adopted as a ratio in both Imperial Tobacco and the Christian Institute case by this court.
I don't think anybody disputes that that is part of the test.
Indeed.
Whether it is the whole test is disputed.
Well, my submission is that that provides us with a suitable test, but in any event, I can go further in the context of the present provisions. But just to give you the references, in Imperial Tobacco, at paragraph 16, MS 917, and in Christian Institute, at paragraph 29, at MS 2826. So it's something that has a connection to a reserved matter which is more than loose or consequential, and that may be sufficient to establish that a provision does relate to that reserved matter. But as I indicated just a moment ago, we don't rely on that test exclusively, or as doing more than to indicate that which is obvious in any event from the words in the statutory approach that is set out in the Act. But even if a closer relationship than that is required, this case is not one which is likely to turn on some matter of degree, because the parties have taken a somewhat absolute set of positions. My learned friend, the Lord Advocate, argues that the Scottish Bill is merely concerned with the domestic statute book and has nothing at all to do with international relations. Now, of course, we submit that withdrawal from the European Union is unquestionably a matter of international relations, and legislating for withdrawal is plainly related to withdrawal and therefore to the matter of international relations. And I simply mention that in our written case at paragraph 31, we point out that legislating for the effect of withdrawal in the manner that the Scottish Bill seeks to do, and during the process of negotiations resulting from that withdrawal, is inextricably bound up with the issue of withdrawal itself. Excuse me. But we do not lose sight of the relating to test. And as can be seen, it is common ground that this may cover domestic legislation which relates to such relations, for example, by implementation of their outcome. And indeed, in that context, I would rely on the submissions made yesterday by my learned friend, the Lord Advocate, that on a fair reading of the policy memorandum, the purpose of the Scotland Bill was to provide for continuity in domestic law of consequences of withdrawal from the European Union. And indeed, my lady and my lords may recollect that the long title of the section of the Scotland Bill itself is absolutely clear in that respect, as is section 1, subsection 1 of the Scotland Bill. And if one might interpose some words into that provision, it's essentially saying this is a bill in connection with, but in some way not related to, the prospective withdrawal of the United Kingdom from the European Union. But just as in Miller, there was no parallel legislative competence in the Scottish Parliament to authorise withdrawal by giving an Article 50 notice, so there's no parallel legislative competence to legislate in this way for the effects of withdrawal. And nevertheless, both types of legislation by the Scottish Parliament would be related to the reserved matter of relations with the European Union. But of course, neither would fall into the exception to that reservation, which is found in paragraph 7, subparagraph 2 of the schedule. So it's quite clear, I would submit, that it's not necessary to establish a direct impact on, for example, international negotiations, although one can assume that that could very well occur in order to establish the sort of impact that we're concerned with. And that's because we, and indeed the Lord Advocate, evidently accept that legislation prior to or indeed consequent upon the conduct of relations with the European Union can relate to those European Union relations. And that was implicit, I may say, in the Lord Advocate's important submission yesterday, that the Scottish Bill, should it become an act, might fall to be amended in the future in light of negotiations with the European Union. It simply underlines the relationship between that bill and the matter referred to in paragraph 7. And the further point that we would seek to emphasise is the scale and constitutional significance of the legislation which is being contemplated by the Scottish Parliament in this context. It is a fundamental matter with regard to our relationship with the European Union. And as I said before, it clearly does not fall within the exception to the reservation in paragraph 7, subparagraph 2. But we would underline also that, as Lord Hope observed in Imperial Tobacco, one approaches the reservations in Schedule 5, bearing in mind certain common themes. And one is that matters in which the United Kingdom as a whole has an interest should continue to be the responsibility of the United Kingdom Parliament at Westminster. And these include, as he observed, matters which are affected by its treaty obligations. And it's undeniably the case that making provision for the treatment of EU law upon withdrawal is a matter affected by the United Kingdom's treaty obligations. Now, the Lord Advocate's case appears now to be that the purpose and effect of the Scottish Bill was simply to provide for continuity and for the consequences of withdrawal. But with respect, the fact that the bill relates to the consequences of withdrawal in domestic law does not take it outside the reserved area in paragraph 7. It's not outside that reserved area simply because it's domestic legislation, a point that he appears to accept. And it cannot be outside when it deals with the consequences of withdrawal. Indeed, on the contrary, that simply underlines the necessary connection. And I would, with respect, have to take issue with the very narrow construction which my learned friend, the Lord Advocate, attempted to place on paragraph 7, subparagraph 1 of the schedule. His case as he explained it yesterday, is and appears to be that reservation covers only things that can be done by the state on the international plane, and then legislation in relation to those things. And the court may recollect that he expressly referred to CRAG, the Constitutional Reform and Governance Act, and legislation made thereunder in consequence of some international treaty obligation or the withdrawal from some international treaty obligation. But that, in my respectful submission, can hardly be a coherent response to the reservation if it only covers things that the Scottish institutions would have no power to do in any event. The Scottish institutions do not have and never had the ability to operate on the international plane. That international plane is occupied by the United Kingdom as the state. So that very narrow approach to the construction of the reservation would essentially strip it of any realistic effect and application. Furthermore, and this is perhaps more fundamental, my learned friend, the Lord Advocate, laid out the foundation for his approach to the construction of paragraph 7, subparagraph 1, on the basis that there were more than adequate safeguards within the Scotland Act which justified the very narrow interpretation that he placed on the reservation. And the court may recollect that he referred in particular to sections 35 and 58 of the Scotland Act. Now, I have to say, with all due respect, that this foundation is a fiction. And I would invite you to look, first of all, at paragraph 7 for a moment in the Scotland Act. That's in Schedule 4. The MS number is 555.
This is Schedule 5, I think.
I'm sorry, my lord.
Schedule 5.
4 or Schedule 5?
This is Schedule 5.
It's Schedule 5, I think you're referring to, yeah.
Schedule 5, paragraph 7, the relevant reservation, which is at MS 555.
Yes. Well, we thought that's what you were talking about, but you referred to the other schedule.
I apologize. And just to look at the wording there, international relations, including relations with territories outside the United Kingdom, the European Union, and their institutions and other international organizations. So international relations, somewhat wide term, including with the European Union, are the subject matter of the reservation. If we then look at the first of the provisions, which my learned friend relied upon, it was section 35, which can be found at MS 431. Subsection 1, if a bill contains provisions which the Secretary of State has reasonable grounds to believe would be incompatible with any international obligations, then he may make an order prohibiting the presiding officer from submitting the bill for royal assent. So, first of all, the court may notice the use of the term international obligations as distinct from international relations, including those with the European Union. And then he went on to rely further upon section 58, which can be found at MS 448. If, as is provided in section 58, subsection 1, the Secretary of State has reasonable grounds to believe that any action proposed to be taken by a member of the Scottish Government would be incompatible with any international obligations,
Same point, yes.
he may, by order, direct that the proposed action shall not be taken. Of Could I then take the court to the interpretation provision at section 126, MS 516. Now, section 126, subsection 1, contains a fairly lengthy series of interpretive provisions. But what is perhaps more important is subsection 10 at MS 517. And that reads as follows. In this Act, international obligations means any international obligations of the United Kingdom other than obligations to observe and implement EU law or the Convention rights. In other words, these safeguards that my learned friend relies upon for his very narrow interpretation of paragraph 7 of Schedule 5 are, when we come to the issue of European law, a mirage. And that, as I understood his submissions, was essentially the only foundation that my learned friend advanced for the extremely narrow interpretation of paragraph 7 that he came to rely upon.
He did refer to the explanatory notes, I think, as well, didn't he?
He did indeed, but it takes one no further in this context, in my respectful submission. So I come back to the simple proposition that it is not difficult to understand what is embraced by international relations, including relations with the European Union in this context. And in my respectful submission, excuse me, it is perfectly clear that the matter of our withdrawal is a matter that engages the whole issue of the reservation. Now, coming on from that point, part of the Lord Advocate's core thesis was that if EU law ceases to apply on withdrawal, that does not affect the allocation of legislative or policy responsibility in Schedule 5, which he would suggest the Scottish Parliament can now exercise in all areas that were previously transferred to or enjoyed by the European Union. But with respect, that proposition assumes that under the Scotland Act, the event and consequences of withdrawal are simply to be treated as if they were any other change in EU law, whilst the United Kingdom remained a member. But of course, that is certainly not the case. Each of the various ways in which we challenge the competence can be taken as illustrative of the difficulties of the Scottish Parliament seeking to legislate as it's done. And they operate to indicate the incompetence and indeed the sheer improbability of the UK Parliament having ceded power in the Scotland Act to enable the Scottish Parliament to do now what it claims able to do. It is perfectly clear and is accepted that the Scotland Act did not anticipate Brexit, nor did it make any provision for the eventuality of the United Kingdom's withdrawal. In truth, it is a matter for the UK Parliament to determine where areas of current EU competence may appropriately lie in the event of that withdrawal. And that brings me to touch upon some of the dicta in the case of Miller that have been referred to, and in particular, at paragraphs 129 and 130 that were mentioned yesterday. And as Lord Hodge observed yesterday, it appeared to some extent at least that both parties were relying upon what was said there, albeit their interpretation of the relevant provisions might not be identical. But if I can take the court for a moment to MS 1105. That's in the core volume 2, Lord's tab 8. And in my respectful submission, the two provisions have to be read together, 129 and 130. And the court observed, because we've concluded that primary legislation is required to authorize the giving of notice, the third question is superseded. The first question is for a similar reason less significant than it otherwise might have been, but we address it briefly. When enacting the EU constraints in the Northern Ireland Act and the other devolution acts, Parliament proceeded on the assumption that the United Kingdom would be a member of the European Union. That assumption is consistent with the view that Parliament would determine whether the United Kingdom would remain a member of the European Union. But in imposing the EU constraints and empowering the devolved institutions to observe and implement EU law, the devolution legislation did not go further and require the United Kingdom to remain a member of the European Union. Within the United Kingdom, relations with the European Union, like other matters of foreign affairs, are reserved or accepted in the cases of Scotland and Northern Ireland and are not devolved in the case of Wales. Accordingly, the devolved legislatures do not have a parallel legislative competence in relation to withdrawal from the European Union. The EU constraints are a means by which the UK Parliament and government make sure that the devolved democratic institutions do not place the United Kingdom in breach of its EU law obligations. The removal of the EU constraints on withdrawal from the EU treaties will alter the competence of the devolved institutions unless new legislative constraints are introduced. In the absence of such new constraints, withdrawal from the EU will enhance the devolved competence. And we consider the effect of the alteration of competence in our discussion of the Sewell Convention and references made to a later provision. Now, of course, removal of the EU law constraints will impact upon the devolved competence, but one cannot read those provisions without taking account of the provision that is made with regard to further steps that the Parliament of the United Kingdom will consider appropriate upon that event in respect of devolved competence. The court in Miller specifically relied on the reservation in paragraph 7, subparagraph 1 of Schedule 5, for the proposition that the Scottish Parliament did not have parallel legislative competence in relation to the withdrawal from the EU. And that is significant because the debate there in the context of paragraph 7 was about the competence of the Scottish Parliament to legislate. So legislating domestically consequent on the conduct of relations with the EU on the international plane was clearly regarded by the court in Miller as coming within the reservation in paragraph 7 of Schedule 5. And that's because such legislation relates to those international relations. Now, of course, it's correct that withdrawal from the EU will remove a constraint upon the competence of the devolved institutions and so enhance that competence. The removal of the EU constraints on withdrawal, it's said, will alter the competence of the devolved institutions unless new legislative constraints are introduced. And of course, the timing of that removal of constraint is a matter of uncertainty. It may occur upon withdrawal or as a result of a transitional period, or indeed as the result of a withdrawal agreement. But the removal of the constraint, by which is meant that the devolved institutions will no longer have to act compatibly with EU law, does not in and of itself imply any transfer of competence formally enjoyed by the European Union to the devolved institutions rather than to the Parliament at Westminster. That does not establish, in other words, the Lord Advocate's core thesis in his submission. Rather, it's plain in my submission that the Scotland Act cannot be said to make provision for the return of competences to the Scottish Parliament, as that was a matter which was never within its contemplation at the time the 1998 Act was passed. And as I say, what we see now is what is being done precisely in the 2018 UK Act. It was not open to the Lord Advocate or the Scottish Parliament to assume that because of withdrawal, or in the course of withdrawal, no new legislative constraints would emerge from the UK Parliament, but that is the underlying assumption that is simply made both by my learned friend and by the Scottish Parliament, and it is simply unjustified. That being so, the process of withdrawal is clearly a matter covered by the reservation in Schedule 5. The Scottish Bill is clearly and indeed expressly related to that process of withdrawal. It is not accepted from the provisions of paragraph 7, subparagraph 1, by virtue of paragraph 7, subparagraph 2. And the Lord Advocate cannot escape from that conclusion on the basis of the very narrow construction he endeavours to place on paragraph 7 by reference to the provisions in section 35 and section 58 of the Scotland Act, which have absolutely nothing to do with that issue. So that really is all that I would have to say on the matter of the reservation and the matter of whether or not the Scotland Bill relates to the matter of relations with the European Union. Could I turn then for a moment to the second matter that I was going to address, which is the matter of modification. Now, first of all, the UK Act has recast the constraints on the devolved legislatures, indeed exactly as envisaged by the court in Miller. And it has, by its terms, recast what the Scottish Parliament is now competent to do in the context of withdrawal. And indeed, that was the very complaint that I alluded to when I opened a few moments ago. The Scottish Government took issue with the fact that the United Kingdom Parliament had now recast the competence of the Scottish Parliament in the context of the withdrawal process. The result of that is not, as my learned friend Mr. Fordham would suggest on behalf of the Council General of Wales, any inconsistency between the reservation in paragraph 7 of Schedule 5 of the Scotland Act and the new scheme under section 30A of the 2018 Act of the United Kingdom Parliament. The new scheme embraces all relevant provisions that exist in the Scotland Act, and the Scottish Parliament's competence is now defined, as it always has been, by reference to what they cannot do. The devolved legislatures always had some competence in respect of the European Union. The UK Act of 2018 simply reenacts the constraints on that competence in the new circumstances which arise as a result of withdrawal. What it seeks to do is to set up a scheme of competence for the whole of the United Kingdom, and what the Scotland Bill endeavours to do is to interpose itself into that function. Now, at various stages, my learned friend, the Lord Advocate, has invited the court to consider the competence of the Scottish Bill by reference to the United Kingdom Act, and to consider the competence of the Scottish Bill without reference to the United Kingdom Act. I take no issue with that inconsistency. But it would be wholly artificial, and indeed I venture undesirable, for reasons already given in the written case, for the matter to be determined without reference to the United Kingdom Act. And ultimately, what could potentially happen is that if the Scotland Bill was found to be within competence, whether after reconsideration or otherwise, and received royal assent, it would clearly do so after the United Kingdom Act had received royal assent. It would then be the subject of consideration of competence by the law officers, amongst others, and there would then be scope for a devolved issue to be raised pursuant to Schedule 6, paragraph 34 of the Scotland Act, which would simply mean that the matter would wing its way back round to this court eventually, with the same issue arising, because of course Section 30, to which the Lord Advocate makes repeated reference, would not operate in circumstances where the Scotland Bill received royal assent after the UK Act. So we would simply be back where we are. So, as I say, we maintain that the court should address all of the issues that arise and have been addressed both in written and oral submissions. The UK Act is a protected enactment. The Scottish Bill does seek to modify it, and it does so in unacceptable ways. And to some extent, my learned friend, the Lord Advocate, has accepted that. But I would wish just to make one or two observations on the matter of modification. A modification of a protected enactment will occur where the protected enactment and its operation as an enactment is affected by the legislation complained of. Now, my learned friend, the Lord Advocate, suggests that an addition to the legislative scheme is not a modification, or that a duplication of the scheme is not a modification. With great respect, these absolutes cannot stand. There may be circumstances where legislation brings forward some additional right or obligation and does not affect the operation of the scheme of a protected enactment. But equally, there may be many circumstances in which an addition does operate to affect the scheme in the protected enactment, and consequently will amount to a modification. And here, of course, reference has been made to the Scottish Bill referring to liabilities under the Charter, under the general principles of EU law, with respect to Frankovich damages. But these are not just additions that are brought in by the Scotland Bill. They impact directly upon wide-ranging aspects of the model, if I can call it that is going to be implemented by the UK Act in the context of our withdrawal from the European Union. And as regards duplication, again, well, in fact, I notice that we're getting duplication now as a term rather than restatement, which is the position adopted in the written submissions. But as regards duplication, again, not every exact duplication may amount to a modification, but there are many instances in which an apparent duplication of the relevant statutory model will amount to a modification of the protected enactment. And I just give us simple examples. Who is going to be exercising a regulatory power? Is it going to be ministers of the Crown, or is it going to be ministers of the Scottish Government? That in itself is a modification of the proposed scheme set out in the UK Act.
Can I just ask you something that is relevant to this? I mean, the point I was putting to the Lord Advocate about what is a provision, and we seem to think it was something sort of just a section or subsection, but possibly a group of sections. But actually, if we look at the actual protected provisions section on MS 541, it's clear that it's regarded as having different effects for different purposes. I mean, can we have a look at that? Because as I understand it, it says an Act cannot modify any of the following provisions. And we then have a list, and some of them are relatively limited. Well, there's the Articles 4 and 6 of the Union. There's a whole Act, the Private Legislation Act. There's various provisions of the Communities Act. There's some odd provisions of the Local Government Planning Act. And then we have the whole of the Human Rights Act.
Exactly.
And added to that, assume we can take into account the UK bill, is the whole of the UK Withdrawal Act. So the provision we're talking about modifying is the whole Act, isn't it?
There are circumstances, and this is why we put our case in the alternative. There are circumstances where an Act of the Scottish Parliament will modify a protected enactment. The entire enactment is essentially modified in its application going forward. And that is what we argue for here in our primary case, that the devolved model contained in the UK Act is being modified. And therefore, it's the entirety of the Act. But then there is a secondary position that if that is not accepted, you can look at individual provisions within the Scotland Bill and within the UK Act to determine the scope of any modification. It might come down to one section of the UK Act. It might be a multiplicity of sections, I suppose. But you could reach the situation in which, having looked at the effects of modification, you end up with residual provisions in the Scotland Bill that are essentially meaningless and don't...
But I think the point I'm putting to is really, I hadn't really looked at that, because when we look at section 33, which tells us what we're doing, we're asking whether a bill or any provision of a bill would be within the legislative competence. But we have to look at that when we relate that to the Relevant Protected Provisions Act in relation to the whole of the UK Withdrawal Act, before we then go on to look at any individual part.
Well, it respectfully appears to me that we may have a situation, and we do have a situation here, where the Scotland Bill modifies the entire scheme of the UK Act as it deals with devolved competence. And I go back to a point I sought to mention earlier, which is that we are in a situation in which the UK Parliament, pursuant to the UK Act, has essentially redefined the competence of the Scottish Parliament. And that redefinition of devolved competence is now modified by the Scotland Bill.
Just getting my head around this. Are you referring to the new section 30A?
Section 30A is introduced by section 12 and schedule 2, which
and
together bring together a new devolved competence. And indeed, schedule 2 itself has its own self-standing definition of devolved competence.
Section 30A isn't brought into force yet, but you would say it can be modified as at the relevant date for our purposes, which I'm taking to be rather sent to the bill. It can be modified even though it's not yet in force.
Absolutely. And just on that point, my Lord, could I underline that Schedule 4 of the Scotland Act does not refer to protected laws, it refers to protected enactments. And in my submission, it's for that very reason. It would be most unfortunate if the UK Parliament brought forward what was intended to be a protected enactment, and it was then amenable to modification because one or more of its provisions had not been brought into force when the devolved legislature decided to bring forward its own provisions.
It's all potentially quite confusing. I mean, we're having to treat the Scottish Parliament's competencies as they are at present, rather than as they may be when Section 12 comes into force. But insofar as the Scottish Bill is aiming to lay down what the law is going to be at some future date, it's proper to see whether that modifies the UK provisions in the UK Act, which may also be brought into force at some future date.
Exactly so. And the complication and difficulty arises, and I don't want to return to it, because of the mechanism employed by the Scottish Government and Parliament in the Scotland Bill, which is to introduce by way of Section 1(2) the means of bringing in legislation that essentially is in cryostasis until some future event.
I mean, you may or may not recall in Christian Institute, we had to carry out a rather similar comparison of a Scottish Act with the Data Protection Act, and we decided it was such an impossibly difficult exercise that the law was not accessible, and that in itself was a breach of an infringement of the competence of the Scottish Parliament.
But here, it is a difficult but not insurmountable problem. But as I say, we take it in two parts. First of all, we say the very scheme of devolved competence that is introduced by the UK Act, pursuant to Section 12 and Schedule 2 of that Act, is being modified by the provisions in the Scotland Bill. But if you want to break that down, then we can go through provision by provision to see where there are modifications, whether it be by addition, duplication, restatement, or any other term that my learned friend the Lord Advocate wishes to employ. And I would just add to that the very fact that the UK Act does not have an analogue for a provision in the Scotland Bill does not in of itself even begin to suggest that the UK Act scheme is not being modified by the Scotland Bill. The very existence of these provisions in the Scotland Bill without an analogue in the UK Act for the purposes of the new devolved competence is itself clear, and I would suggest fairly convincing evidence of it being affected and therefore modified by the Scotland Bill. So I really cannot accept any of the labels that my learned friend the Lord Advocate seeks to put upon the provisions in the Scotland Bill, whether it be duplication, addition, restatement. One has to look a little further and consider whether any of these provisions in the Scotland Bill affect the scheme of devolution of devolved competence, which has been evolved by the UK Parliament for the purposes of exit from the EU pursuant to, as I say, Section 12 and Schedule 2 of the Act. And it was that which the Scottish Government took issue with from the beginning. And as I mentioned earlier in the policy memorandum, they specified, this is why we're going to go in a different direction. We cannot accept this. But they had no competence to do what they've now done in the face of the provisions of the UK Act. And that is where we conclude so far as modification itself is concerned.
Well, that's very good timing, Advocate General. You're just about exactly correct.
At that point, therefore, my lady, I will close my submissions unless there are any further points that my lady and the Lords wish to raise. I'm most obliged.
I think not. Thank you very much indeed. And thank you to everyone for the help they have endeavoured to give us in this complicated matter. This is definitely one for the wet towels, so we'll go away and apply them and let you know the outcome as soon as we possibly can. Thank you.